Next, much like when I introduced Her Honor Judge McLeod, we have another special guest here this morning who has now gone to the bench, but for years he was always among us. He was always one of the leaders of the bar, always participating in these seminars. He's a great guy, totally committed to the Criminal Lawyers Association when he was in practice, and we're delighted to have him here this morning, Mr. Justice Bruce Durno. How do you like Fallen Jeffrey?
I'm going to mention that. As you'll see, one of my my topic is that one style doesn't fit all lawyers and all witnesses. For those who felt that I wouldn't be able to deliver the message, they decided to put Jeffrey first, and dull and boring Durno comes second. I heard once of Jeff having a case with a Crown attorney in Hamilton, whose name escapes me, who speaks just about as quickly. Miss Joe Nadell speaks just about as quickly as Jeffrey. I wanted to nominate the court reporter for the Martin Award that year. I mean, anybody that could keep up with the two of them. A few years ago, I was talking to a judge who has a great deal of experience in criminal law, and he was telling me what a fantastic job a young lawyer had done in a cross-examination in front of him. Ran into the judge about 3 months later, and the same lawyer was back in front. And he said, same lawyer, same style of cross-examination. It was a disaster. It didn't work. It was the wrong cross-examination for the wrong case, the wrong witness. Some people cross-examine, and in my new position I see it occasionally, one style fits all witnesses. Usually it's the frontal attack, the cross-examination. You see juries sort of, and the eyes go up to the ceiling. It's not working. In my view, you've got to take a flexible approach and decide before you start cross-examining a witness, what are your objectives? Who's the audience? And factor in your own style and your own personality. Now, unfortunately, the art of cross-examination is becoming more difficult, thanks to the federal government hybridizing offenses. You're going to have to cross-examine more frequently a witness who you have never seen before at a preliminary inquiry. Because with the hybridization to date and the hybridization that's coming down the road, a sweeping change, you're going to have to do it without the preparation of a preliminary inquiry. In psychiatric work, multiple personality is a disorder. For the cross-examiner, I think it's a prerequisite. The DSM defines multiple personality disorder as the presence of two or more distinct identities or personality states that recurrently take control of behavior. I think that's what you have to do in cross-examination. However, even people, and there's some debate whether there is such a thing, but let's assume there is multiple personality disorder. Even those who have it don't have every single personality. You have to know which personalities you have on the shelf that you can use in any particular case. Not everyone is miserable and abrasive naturally. Maybe they can act that way. You have to assess what will work for you. The best example, I think, is occasionally people will try and laugh cases out of court. We've seen it with other counsel. I haven't seen it yet in the 8 or 10 months that I've been sitting. Most times it doesn't work. Dave Humphrey could do it when he was at the bar. It is a rare trait, and I would really caution against doing it, trying to do it too often. One, your personality may not make it work, and secondly, it may not be the right case for it. And if it backfires, particularly with a jury, the one who's going to pay is the accused. What type of style are you going to use in a particular case? The frontal assault, that cross-examination? Are you going to have to treat the witness with kid gloves because they're dangerous? They're great counterpunchers. You know they're going to give it to you right between the eyes if you leave any opening for them. Or are you going to be the Pied Piper? Are you going to just sort of lead them step by step by step by step to where you want them to go? You have to realistically assess what you're going to be able to do at the outset. While it would be nice, it's rare that you're going to be able to make the singing nun look like Karla Homolka. You've got to be able to look at your objectives, and what are they? First of all, what do you have to do in cross-examination? I've referred in the materials to Brown and Dunn in the Court of Appeal case in Varney. I'll just leave those. You can look at those as what you're required to put to a witness, and Earl Levy's going to deal with it in any of it. Second, what are your client's instructions? What's the client's going to testify, if the client is going to testify? Client determines if they testify, what the plea is, whether they have a preliminary inquiry, whether they have a jury. That's it. But if the client says that incident never happened, then you're going to have to confront that witness who says it did. Are you going after the witness's credibility, that they're lying? That may call for the frontal assault. Are you looking just at the witness's reliability, the identification witness? They believe they're telling the truth. They may be mistaken. That calls for a different approach in cross-examination. Jeffries dealt with prior inconsistent statements, and that you're certainly not going to use them at a preliminary. Are you just setting the table? Are you setting the table for the trial? You want to do what Jeffrey spoke about in terms of the prior inconsistent statements at the preliminary inquiry? Or are you setting the table perhaps, and this may cause you to go further at the preliminary inquiry, for the Crown Attorney, who has indicated, if you accept what the Crown Attorney has said to you, that they want to assess how good or bad the witness is in terms of reasonable prospect of conviction. If you believe the Crown Attorney, you may want to go farther. Are you setting the table for the judge at the pretrial, where you can get some good answers? Show the judge at the pretrial at the next level, look, this case isn't going anywhere. And if you've got a Crown who is susceptible to being leaned on, maybe the judge can help you out. What you want to avoid in terms of your objectives is, first of all, that, as we've all had the experience of getting it right between the eyes. Try to know who the witness is. And you can ask, I mean, not so much with civilians, but with experts. You can contact other counsel, Criminal Lawyers Association. You can contact, in terms of now after Kaufman, with jailhouse informants. You're going to get all of the times that they have testified before, if they have. You're going to be able to get a hold of counsel. Try and assess the witness before you go in, and that's what is going to make it so much more difficult with fewer and fewer preliminary inquiries. Don't forget Section 715, that evidence can be read in. You also have to take a flexible approach, and I'll speak in a moment about listening to the answers, but going in with a game plan can be very difficult. And I must confess, when I started off, I went in with game plans. And I was like a poor football coach. At halftime, if I was losing, I couldn't vary it. You've got to be able to switch personalities given the answers that you receive from the particular witness. A couple of things that you should not do, one, if there's any Crowns here, is to let the police dictate the cross-examination. Particularly where I'm sitting now, it's amazing how often you see the police officers sort of tugging at the gowns with their wonderful suggestions as to which questions should be asked in cross-examination. Fortunately, I've kept my mouth shut so far. I'm not sure that will last too much longer. The other thing is that the accused shouldn't dictate the cross-examination. You can tell the accused what you're going to do. But if it's a reliability case, it may not call for the frontal attack on the witness, as, for example, in an identification case. The client doesn't control it. And finally, you've got to remember your audience. Are you pitching to a jury? Watch the jury. or have someone watching for you? Are you pitching to a judge at a preliminary inquiry where there's any issue at all for committal? Who's your audience? Because who the audience is will dictate, to an extent, what style you're using. Finally, in terms of the length of cross-examination, some cross-examinations, and what I'm seeing now, I think this may shock some people, are too short. And the difficulty is, I think, that people, and I did it starting off, I had all the questions written out, almost word for word, because I wanted to make sure I had every question covered. And what I did was I focused on the questions. When a judge says to you, how long are you going to be in cross-examination, I think your answer should be, it depends on the answers. It's the answers that dictate. And if you get focused into your questions, you're going to let witnesses avoid answering the questions. For some reason, on occasion, police officers have some difficulty understanding the English language. A direct question, particularly an experienced officer, they'll do an end run. They will not answer the question. Keep asking it. I mean, nobody's objecting. It's a proper question until you get the answer that's responsive to that question. And as I say, I'm seeing it now that particularly with certain types of witnesses, they're not going to answer. Please speak English. Is it better to say, here's the next exhibit, or I'm going to present you at this particular point in time a second proposed photograph and sequential exhibit? Juries in particular, I think, and some judges, appreciate people speaking English. Get rid of the lawyer talk in terms of your cross-examination. Know when to hold them. When you get the good answer, don't cheer, don't smile at the client, give the high five. It gives the witness a chance to reconsider and zing you with a qualifying comment at the end of it. Know when to fold them. Some witnesses are going to kick the living daylights out of you. You try and avoid it, but it can be painful. Do what you have to do. Watch the jury or watch the judge. Judge Ferguson, who retired a few months ago, was always big on saying, when I put my pen down, you can rest assured you're not scoring any points at all. And on some occasions, and I think you've heard it from earlier speakers this morning, the best cross-examination, when you look at the objectives you want to achieve, may be no questions.